The reports of the committees and commissions are also considered important source of administrative law. They have played major role in the development of administrative law in England. The reports of the committees on ministers' power, also known as Documentary Dogmery Committee, 1932. The Farouk Committee and Administrative Tribunals and Enquiries, 1957. Select Committee on Statutory Instruments, National Insurance Advisory Committee, etc., have played an important role in the development of administrative law. The reports are given due importance in other Commonwealth countries also. In India, reports of Law Commission and of parliamentary committees on subordinate legislation have played an important role in the development of administrative law in India. The Fifth Law Commission, in its first report, has prepared a bill in order to define the extent of the territorial liability of the state for the act of its servants, but unfortunately no law has yet been enacted. The liability of the state for the tort committed by its servants are determined on the basis of principles developed by the courts. The liability of the state for the torts committed by its servants are determined on the basis of principles developed by the courts. In India, reports of law commissions and parliamentary committees on subordinate legislation have played an important role in the development of the administrative law in India. The Fifth Law Commission in the first report has prepared a bill in order to define the extent of the territorial liability of the state for the act of its servants, but unfortunately no law has yet been enacted. The liability of the state for the torts committed by its servants are determined on the basis of principles developed by the courts. Administrative tribunals. The administrative tribunals have been formed under different statuses. All these tribunals are subjected to superintendents and adopting different procedures. These tribunals are made not necessary by judicial officers, yet discharge functions by observing the basic judicial procedure. Other powers. Administrative tribunals. The administrative tribunals have been formed under different statuses. All these tribunals are subjected to the superintendents and observing different procedures. These tribunals are made not necessary by the judicial officers, yet discharged functions by observing the basic judicial procedure. Other power control techniques. The growth of administrative process has been accelerated all over the world due to the emergency of highly complex society and synthetic social living. Governance has increased. Consequently, government interface has resulted consolely. Therefore, there is a need for corresponding mechanism with suitable tools to check the increased powers of the government. The existing old judicial instruments without modular tools do not suit the present powerful state. Beside the new tools being made by judicial, a service for the other institutions is on the new found instruments are the ombudsman, Lokyukta, Lokpal and Central Vigilance Commission. Origin, development and growth of administrative law. The origin of administrative law is an old as executive power, but it witnessed tremendous growth and development in the 20th century in France. The administrative law in or administrative was fully developed even before the 20th century. Administrative law related to the public administration. Administrative law relates to the public administration, and therefore it has been in some form or other in even country has some form of government. Dorrit administrative or original development in France. France administrative law is also known as Dorrit administrative. It is branch of law or body of rules which determines the organization's powers and duties of public administration and regulates the relation of the administration with the citizens of the country. It does not respond rules and principles enacted by the parliamentary. It contains the rules developed by the administrative courts. According to Deasy in his Law of the Constitution 9th 1939 p. 495, Dorrit administrative is that portion of administrative law which determines the position and liability of the state officials, the civil right and liability of the private individuals in their dealings with officials as representatives of the state, and the procedure by which these rights and liabilities are enforced. Dual judiciary in France. In France, legal system known as Dorrit administrative. There extend two systems of courts, namely civil courts and administrative courts, and dual system of law which is independent of each other. The ordinary courts administrator, the ordinary civil law as law subject and subjects the administrative court administrator. The law as determine the subject and the state. An administrative authority or official is not subjected to the judicial of the ordinary civil court exercising powers under the civil law. In dispute between the private individuals, all claims and disputes in which these authorities or official or parties falls outside the scope of judication of ordinary courts, and they must be default with the decided by the special tribunals through the system of Dorrit administrative is very old. It was recently put into practice by Napoleon in 18th century. Dorrit administrative is very old legal system. Napoleon who afford Dorrit administrative put it into practice in 18th century. He established an institution called Conseil d'Estate to give relief to the people against the excess of the administration. The main object of Conseil d'Estate established in 1799 was to resolve difficulties which arises in the course of the administration. Its main function was to advise the minister. Later it started exercising judicial functions also. In case of conflict between the ordinary court and the administrative courts, the matter is decided by the tribunals. Conflict. These tribunals consist of equal number of judiciary of both ordinary courts and administrative courts. Another aspect of Dorrit administrative is that it protects government officials from the ordinary courts. Main features following are the main features of Dorrit administrative. Dual system of court, separate administrative court, Conseil d'Estate, Tribunal de Conflict, and application of special rules. Dual system of courts, separate administrative courts. In France, there was two types of courts: regular or ordinary courts and administrative court. The cases concerning the administrative officials are in which state is party with the exception of criminal cases are tried and decided by the administrative courts head by council de estate. The ordinary civil courts decide that cases between the subject and subjects. The ordinary courts administrator the ordinary civil laws between the subject and the subjects, while the administrative courts administrator the law as between the subjects and the state as a between the subjects and the administrative officials or authorities. The administrative authorities or officials are not subject to the ordinary courts but to administrative courts. The administrative courts decide the cases according to the rules developed by the administrative courts themselves, though the cases brought by the private citizens against the administration are decided by the administrative courts. Conseil d'Estate, it is the highest administrative court in France. It was established by Napoleon Bonaparte in 1799 with the object of providing relief to the citizens against the exercises of the administration. In the beginning, it performs the function of resolving difficulties found in the course of the administration, but later it started exercising judicial powers in the matter involving the administration. In the beginning, its function was advisory, and it was not an independent court. Its main functions were to advise the ministers and not to give judgments. Gradually, its powers were increased and it started exercising judicial functions in 1872. Its power to give judgment was formally accepted and established in 1873. It was settled that in all matters involving administration, its jurisdiction would be final. Though at present, all the matters involving administration are decided by the administrative courts headed by the Council d'Estate according to the rules developed by themselves. Council d'Estate is at present not only a judiciary but also consultative body. Council d'Estate consists of civil servants in France. It is an part of the France administration. It is divided into several sections: judicial sections, advisory sections, etc. The judicial sections has again been divided into several sections. Tribunal de conflict, dispute as to jurisdiction between ordinary courts and administrative courts are determined by a separate court called Tribunal de Conflicts. A case concerning an alleged conflict of jurisdiction can be raised only by administrative courts and not by the ordinary courts. Tribunal de Conflict consists of an equal number of judges for ordinary civil court and judges for Council d'Estate, and presided over by the Minister of Justice, and its decisions regarding the jurisdiction in final. Application of special rules as has been stated above, all the matters involving administration are decided by the administrative courts and not by the ordinary courts. Such cases are determined by the administrative courts according to the rules developed by the administrative courts themselves. Application of special rules. As has been stated above, all the matters involving administration are decided by the administrative courts and not by the ordinary courts. Such cases are decided by the administrative courts according to rules developed by the administrative courts themselves. Critical appraisal of France administrative system. Dorint administrative. France administrative system is subject to criticism. Professor Deci, an eminent jurist viewed that the administrative courts, being part of the administration, could not have independent status as the judiciary and could not protect the citizens against the abuse of the power by the administration. Critical appraisal of France administrative system. France administrative system is subject to criticism. Professor Dicey, an eminent jurist, viewed that the administrative courts, being part of the administration, could not have independent status as the judiciary and could not protect the citizens against the abuse of the power by the administration. He thought that the administrative courts were established to protect the government officials from the court of the ordinary courts, and he took it as a preferential terms to the government officials and against the principles of equality, which is a part of the rule of law. He though held the view that there was no rule of law in France. The criticism by Dicey was found to be baseless. Recent release shows the Council d'Estate has done so much for the protection of the citizens against the excess of the administration compared by the ordinary courts in other countries. Consider all these developments. Dicey himself in his law days realized his misconception and ill-founded notation against Dorrant administrative and Council d'Estate. He regretted his failure to notice the vast area of administrative law exercising in England when he rules of law these was published. Ordinary and development in England. Position in England. In England, the existence of administrative law as a separate branch of law was not accepted until the advent of the 20th century in 1885.